While order dated 12 February 2019 passed in Aligarh Muslim University versus Naresh Agarwal made this reference to a bench of 7 judges with a view to determine the correctness of the question arising from the decision of this court on Aziz Basha, which had ruled against the minority status so to be accorded to AMU. Second, to determine question 3A formulated in TMA Pi. And third, whether the decision of this court in Professor Yaspal versus Chhattisgarh State of Chhattisgarh and the amendment in 2010 in National Commission for Minority Education Institute Act 2004 have any bearing on the aforesaid question formulated. The fulcrum of this reference rolls around the interpretation of Article 30 of the Constitution of India, which deals with the right of minorities to set up education institutions. We have had the benefit of perusing the erudite majority opinion authored by Honorable the Chief Justice Dr. D.Y. Chandrasud. While the said opinion comprehensively addresses each issue with depth and clarity, we have expressed a differing view on the interpretation of certain aspects given the significant constitutional implications involved. Recognizing the weight of these issues, we have chosen to offer our own perspective, though we acknowledge the thoroughness and diligence with which Honorable Chief Justice has approached this complex matter. Before we lay down the indicia under Article 30 to determine whether an institution has a minority character and ought to be afforded protection, we deem it appropriate to embark on a substantive analysis of the issues involved and will begin by undertaking a comprehensive examination of the multifaceted nature of minority rights both in India and internationally. Then, after discussing the international and within India how the minority rights have been developed and established, then I have referred to the constitutional scheme which ultimately led to formation of Article 29 and 30. Then we have explained the statutory scheme of National Commission for Minority Act 1992 and other relevant statutes having any bearing. Thereafter, I have referred to the brief history of AMU and followed by the features of the AMU Act 1920. Of course, for the reasons which I have assigned later on, these provisions we have not interpreted at this stage. We have only highlighted that what was the statutory scheme. Then we have explained the challenge to the constitutionality of the 1951 and 1965 Amendment Acts in the AMU Act of 1920 and the contentions which were raised in Aziz Basha when these amendments came to be challenged. After taking notice of the rival contentions which were raised before the 5-judge bench in Aziz Basha, then we have also briefly culled down the conclusions drawn by this court in Aziz Basha. After that, we have given the history of discordance with Aziz Basha. There we have said, having analyzed Aziz Basha, it is imperative to also take account the decisions proffered by this court in other relevant cases to holistically understand the background of the reference before this court. Then, after referring to the 1972 amendment in the 1920 Act, we have referred to thereupon the first discordant note was struck by a 2-judge bench of this court in Anjuman. That was a case where the court was considering the minority status of an institution established by a society registered under the Society Registration Act 1860. The question raised therein pertained to whether such registration would be determinative against the minority status of this institution. In this regard, then 2 questions were formulated that we have reproduced. And after discussion, we have said that almost 2 decades after the reference in Anjuman came the magnum opus decision of the 11th bench in TMA Pi. In this case, the court was tasked with analyzing the different facets of Article 30. Then question 3A, which was not answered in TMA Pi, is reproduced. Then after giving history that how the Anjuman was also disposed of, we have referred to the contentions raised in the present case on both sides, the appellant side as well as the respondent side. And after that, we have notified the issues which arise for determination. There we have said, thus, in our considered opinion, the instant reference based on the question of the test required to be fulfilled by an institution for seeking protection under Article 30 of the Constitution of India can be broken down into following segmented questions of law and fact. The first prefatory issues are: what are the requisite parameters of reference to a larger bench? What matters were intended to be addressed by the larger bench in Anjuman? What are the facets required to be considered by a regular bench of making a reference is made to a larger bench? What are the powers entrusted to the Chief Justice of India in such circumstances? The second question is whether appellant has the locus standi to bring the present challenge. On the constitutional interpretation, the questions which you have formulated are: what are the tests to seek protection under Article 30 of the Constitution? And what is the meaning of the term established in Article 30? Next is, what is the meaning of the term administer in Article 30? Whether AMU satisfy the test of establish and administer and is thus entitled to the protection of Article 30. Whether the Union of India is obligated to defend the AMU Amendment Act 1981. On the prefatory issue of that what are the requisite parameters of reference to a larger bench, I have opined that the issue concerning the power of a regular bench to refer a matter to a larger bench must be examined in light of the order passed in Anjuman, which opined that Aziz Basha required reconsideration by a larger bench and proceeded to refer it to a 7-judge bench. To this end, the respondents have vehemently contended that such a reference was bad in law and should be declared so. In this vein, we have identified two key aspects of the issue. One, what are the issues identified in Anjuman which are intended for the larger bench to address, and two, whether the manner of making such a reference was legally sound. On the first part, we have said it is crucial to determine whether the bench in Anjuman intended to restrict the reference in such a way that the 7-judge bench would only analyze the criteria necessary for an institution to qualify as a minority institution under Article 30 of the Constitution. For the sake of clarity and despite the risk of repetition, we find it essential to put forth the relevant extract. Then again, we have reproduced the reference order and then explained a plain reading of these observations revealed that the 2-judge bench in Anjuman doubted the correctness of the decision Aziz Basha and the principles enunciated therein. The bench, while questioning the holding of Aziz Basha, also borrowed strength from the views expressed by some jurists. In Aziz Basha, the issue pertained to the constitutional validity of AMU 1951 and 1965 Amendment Act. While questioning the correctness of the decision Aziz Basha, it is evident that the reference in Anjuman also insinuated that potential errors may have occurred in the analysis of the constitutionality of those enactments. The reference seeking to reopen the issues settled in Aziz Basha thus necessarily mean not only to re-examine the correctness of that decision, but also an attempt to revisit the constitutionality of the AMU 1951 and 1965 Amendment Acts. Importantly, the key term used in the reference order in Anjuman is "and," which is clearly used to state that both Aziz Basha's case may also be considered, and second, the ingredients of a minority institution should be examined definitively. Such an analysis would also have to consider the question posed in TMA Pi under 3 sub A regarding the criteria required for an institution to qualify as a minority institution under Article 30 of the Constitution, and consequently as to whether AMU fulfills such criteria or not. We therefore find it difficult to align ourselves with the opinion expressed by the majority led by Honorable Chief Justice, according to which the reference before us was limited to determining only the criteria an educational institution must meet under Article 30 of the Constitution. However, given the Honorable Chief Justice decision to further refer the matter pertaining to AMU to a regular bench, we have confined our views to discerning the relevant indicia under Article 30 so as to avoid binding or influencing the regular bench that will ultimately decide the factual issue. Then on the question of manner of making reference to a larger bench, we have said the 2-judge bench in Anjuman, after expressing doubt about the correctness of Aziz Basha and its principles, referred the matter for reconsideration to a larger bench. Additionally, the bench in Anjuman specifically stated that the larger bench reviewing Aziz Basha, a decision by a 5-judge bench, should consist of 7 judges. The decision further directed that the matter be placed before Honorable Chief Justice for appropriate directions. Such a reference, to our mind, is not consistent with the established norms of judicial propriety. There are several reasons which substantiate this school of thought. For instance, Order 7 Rule 2 of the Supreme Court Rules 1966 as applicable during the time of the reference was made. We have reproduced the rule. In this regard, it is imperative to refer to the findings of the Constitutional Bench in Central Board of Daud Bora Community, that subsequent Constitutional Bench, which while adjudicating the correctness of previous decision on the Bombay Prevention of Excommunication Act also laid down pertinent principles on the procedure of making references. The decision in Daud Bora essentially clarified the framework concerning how a reference should be made, particularly when a bench of lesser strength doubts the correctness of a decision by a larger bench or co-equal bench. After referring to Daud Bora, we have said the principles enunciated in Daud Bora reinforce the provisions of the Supreme Court rules referred to earlier and also reiterate the well-established principles based upon doctrines of predictability, consistency, finality, and the principle of stare decisis. The 2-judge bench in Anjuman ought to have understood and applied the law consistent with these principles. The two-judge bench in Anjuman, being of lesser strength than the five-judge bench in Aziz Basha, lacked the authority to explicitly question the correctness of Aziz Basha and refer the matter to a seven-judge bench. In Anjuman, the bench not only referred the matter but also specified the numerical strength of the bench to which it should be referred, with a further direction that the matter be placed before the Chief Justice for the limited purpose of notifying the composition of the seven-judge bench. With utmost respect at our command, we do not appreciate as to how a two-judge bench could dictate its viewpoint to the Chief Justice of India. Thus, to our mind, effectively impaired the Chief Justice authority as the master of the roster. Allowing such a practice would enable benches of lesser strength, such as a two-judge bench, to undermine the decision of larger benches, potentially even as 11-judge bench. This would also place the Chief Justice of India in an untenable position, which would be bound by a judicial order, who will be bound by a judicial order, which, while acting in an administrative role, leading to procedural complications and embarrassment. We reiterate that such action completely undermines the principles of stare decisis, a well-established doctrine that mandates the consistent application of legal principles once pronounced by authoritative courts. This principle is rooted in the idea that once a court has determined a rule applicable to a specific set of circumstances, it should be followed in all future cases. After that, we have explained the principles which govern this issue, and we concluded we thus have no hesitation in holding that it is the Chief Justice of India alone who is the custodian of the authority to determine the composition of benches and the public, in public or national interest, place a matter before any bench he deems appropriate, even in the absence of any reference. That being so, now we have said that 2019 reference order, which was by a three-judge bench, which included the then Chief Justice of India, cannot be faulted. Consequently, based on that order, we consider it appropriate to proceed with the determination of some of the issues concerning the constitutional challenge. We also respectfully disagree with the majority opinion authored by Honorable Chief Justice in paragraph 39 of his draft judgment, according to which Anjuman has merely doubted and not disagreed with Aziz Basha. It seems to us that the term doubt and disagree broadly carry similar connotations. It is difficult to doubt a judicial opinion unless we disagree with the correctness of the contents and substance. Similarly, a disagreement would originate only when such opinion is shrouded with doubts on law or on facts. Then, after explaining these principles, of course, as we have said that the 2019 reference was maintainable because that was a bench presided by Honorable Chief Justice. In conclusion, while fundamental rights cannot be applied, now before that, we have explained the locus of the pre-constitutional institution, that we have held that appellant is entitled to, the pre-constitutional institutions are also entitled to seek protection of Article 30. The conclusion drawn in this regard is, in conclusion, while fundamental rights cannot be applied retrospectively to disrupt pre-constitutional practices, the appellant is not barred from asserting a claim under Article 30 as long as the necessary conditions of this provision are met. Individuals or institutions who qualify to be protected through a fundamental right as of 26 January 1950 are entitled to enforce these rights under Article 32. Therefore, the appellant's locus standi cannot be dismissed on this basis. Now, on the question, we have said, as regard to the fundamental right claimed by the appellant, we have said, based on the foregoing discussion, we believe that the right ensconced under Article 30 belongs to the second category, namely, it is granted to a minority community at large, but can be exercised by an individual or a group of individuals. There was an objection whether writ petition at the instance of individual was maintainable. This right does not fit into the first category because Article 30 specifically aims to uplift and protect certain minority communities, making membership in such a community a necessary precondition. At the same time, however, it is also distinct from the third category because the protection envisaged in Article 30 is toward individual belonging to such a community and not the entire community as one single entity. Thus, while the rights exist for the benefit of the whole community, it can be exercised by its individual members rather than requiring collective action by the whole community. That issue also stands decided in favor of the appellant. Now, coming on the question of interpretation of Article 30, we have held that since the term and has been consciously employed instead of or, it is clear that the text of the provision itself envisages the conditions to be read consecutively. To hold to the contrary would require reading down an original provision of the Constitution which the court must refrain from doing. Considering that institutions claiming any benefit under Article 30 must satisfy this two-pronged test, it is right to say that the terms establishment and administration under Article 30 are conjunctive. After that, we have held, hence, while the parties are right in pointing out the relevant factors of genesis and the statutory sanction, the analysis of who established the education institution has to go beyond them to cover all aspects holistically. Since these factors would be a question of fact that would differ from case to case, giving a laundry list of all such aspects would be erroneous in law. However, to determine whether the minority community has established the institution or not, a few illustrative factors that the courts have considered in the past may include. Then we have highlighted certain instances where the courts have rejected or accepted the claim based upon, and those findings we have illustratively referred to. About UGC Act, we have said the NCME Act or UGC Act and Professor Yaspal are also not in, there is no discordance between them and the Aziz Basa. To that extent, we have said Aziz Basa holds to the contrary, deserve to be. Only one aspect we have concluded about Aziz Basa. It seems to us that when the UGC or colonial laws mandated universities to be created by statutes, those who intended a university, including the minority community, were not absolved from complying with other relevant factors so as to bring the university into being. We therefore do not find any conflict between the amended provisions of the NCME Act, UGC Act, and the holding in Professor Yaspal. Each holds its own independent and distinct field and operates validly within their sphere. The minority community thus can establish a university under Article 30, provided it fulfills the norms of the UGC that gets legal sanction to create the university through a statute. To that extent, Aziz Basa holds to the contrary, it deserves to be modified and clarified. Then we have said, to conclude the discussion on the meaning of established for an institution to fulfill the establishment prong under Article 30, it is necessary for it to have been brought into existence by the minority community and must be working towards the benefit of that community. Another conclusion on administration is, to this end, the very concept of administration is inherently fluid and a specific definition is likely to be under-inclusive. Determining whether a minority community exercises control over an institution is a factual question that varies from case to case. Although there is no definitive test to ascertain whether administration lies with the minority community, various judicial precedents provide indicators that may be considered relevant. Then on an illustrative basis, we have referred to those indicators which have been followed from time to time. And ultimately, we have said, to summarize, the test for administration under Article 30 involves identifying who holds effective and overall control within the institution. While external authorities may assist in its administration, the decisive influence and the control must rest with members of the minority community. To meet this test, the minority community must exercise both active and reactive control, ensuring that the administrative powers are genuinely held in both de jure and de facto terms. On the question of Union of India, whether it should challenge or support the amendment, we have said this question is ultimately only academic. Then we have identified the areas of divergence with the majority opinion. In light of the above discussion, we find ourselves at variance with the majority opinion authored by Honorable Chief Justice of India on the following issues. 1. Whether the opinion of 7-judge bench in Kerala Education Bill, while according to Honorable Chief Justice, was followed by a 6-judge bench in Siddhasbhai Sabhai, has been overlooked in Aziz Basa. There we have explained that in Kerala Education Bill, this court in no uncertain terms opined that there is no reason why the benefit of Article 31 should be limited only to the education institutions established after the commencement of the Constitution. The language employed in Article 30 is wide enough to cover both pre-Constitution and post-Constitution institutions, and that Article 30 gives two rights to the minorities, namely to establish and to administer education institutions of their choice. The right to administer obviously cannot include the right to maladminister. The minority cannot surely ask for aid or recognition of an education institution run by them in unhealthy surroundings, etc. In Siddharth Bhai, the challenge was laid to a government order directing that 80% of the total number of seats in non-government training colleges should be reserved for school board teachers deputed by the government. What comes to light in Siddharth Bhai is that the bench therein did not rely upon the opinion delivered by the 7-judge bench in Kerala Education Bill, and rather distinguished it as the latter was relied upon by the state. The Constitutional Bench in Siddharth Bhai thus took pains to explain that the opinion in Kerala Education Bill was distinguishable and that it is not an authority for the proposition submitted by the Additional Solicitor General that all regulative measures which are not destructive of the character of the institution established by the minority, provided the regulations are in the national or public interest, are valid. We now turn to examine whether the 5-judge bench in Aziz Basa failed to follow the principles opined in Kerala Education Bill or those laid down by the 6th-judge bench in Siddharth Bhai. In so far as Kerala Education Bill is concerned, Aziz Basa categorically holds that the protection of Article 31 was not restricted only to educational institutions established after the Constitution came into force. Such a restrictive interpretation was held to be contrary to the opinion delivered in Kerala Education Bill and was bolstered with strong language that if that interpretation was given to Article 31, it would be robbed of much of its content. The bench further held that the expression established and administered must be read conjunctively in response to a plea that even if an education institution was not established by minorities, it could still be administered by those under the ambit of Article 30. This view, which has been consistently affirmed in the later decisions as well, in our considered opinion, is the correct interpretation of Article 31. As regard to Siddharth Bhai, it was neither cited nor was particularly relevant in the context of the controversy that arose for consideration in Aziz Basa. Most pertinently, the decision in Siddharth Bhai is no longer a good precedent to the extent of disapproval of its view by 11th bench in TMA Pi in this regard. We therefore see no concordance between Kerala Education and Siddharth Bhai on one hand and Aziz Basa on the other. On the second point where we have not been able to find ourselves in agreement is whether there is any conflict between Aziz Basa and the principles enunciated in TMA Pi. On a cogent reading of paragraph 106 to 108 of the draft judgment circulated by the majority, gives an impression that Aziz Basa had some collision with the subsequent 11th Constitutional Bench in TMA Pi. In this regard, a reference has been made to paragraph 70, authored by Honorable Justice Kirpal, as his lordship then was. We are, however, unable to find any such perceived conflict between the two decisions. TMA Pi considered the scope of regulating the right of administering government-aided private minority institutions from paragraph 82 onwards. Then we have reproduced para 93 of TMA Pi, and after discussion, the answer given in para 107 of the TMA Pi. It may thus be seen that the decision in Siddharth Bhai, which holds that the fundamental freedom under clause 1 of Article 30 is absolute in terms, if not made subject to any reasonable restriction, has not found favor and has been expressly disapproved by TMA Pi. On the question of 2-judge bench, whether competent to make a reference, as already explained, we have again reiterated that such a reference could not be made. Further, there is no substantial difference between doubting or a larger bench or disagreeing with such judgment. Doubt and disagreement both originate from a template opinion, which is in conflict with reasons already assigned by the larger bench. There cannot be disagreement without doubting the correctness, and there cannot be a doubt unless disagree with the reasons. Most importantly, entertaining a reference by 2-judge bench doubting a larger bench would dilute the authority and position of the Chief Justice of India as enjoyed upon under Article 145, read with the Supreme Court Rules 1966, as were then applicable. Then what is the true import of entry 63 of list 1 of the Constitution? We have explained entry 63 in two parts, first part and second part. As regard to the first component of entry 63 is a substantive part, which is a constitutional declaration of BSU and AMU to be institutions of national importance. The opening part of entry 63 manifestly indicates that the Constituent Assembly was determined to confer such an elevated status on both BSU and AHU. The second component of entry 63, on the other hand, permits the Parliament to declare any other institution also to be an institution of national importance. It seems from the language of entry 63 that the Parliament has no power to take away the status of an institute of national importance conferred upon BSU or AMU, save and except by following the route of an amendment to the Constitution itself. But we have said route of Article 246 can be followed for the purpose of declaring any other institution as an institution of national importance. Having delineated the issues of disagreement with the majority opinion, we may hasten to add that one of the conclusions assigned in Aziz Basa is such that it deserves to be revisited. We say so for the reasons that then we have explained, as already pointed out. Our conclusion is that to the extent it, and I will just read that part, in this context, it is our considered opinion that the establishment of university, whether as a minority institution or as a religion-neutral institution of high standard, is a complex and mixed question of law and fact. The legislative intent behind the establishment of university or an institution will have a significant role in determining the status of such institution. For instance, if the preamble or the statement of objects and reasons of a statute explicitly state that the university or the institution concerned is intended to be established and shall be administered by a minority community, we see no reason as to why such a university or institution would be denuded of its minority character merely because it was created through legislative means. Conversely, if the legislature by itself decide to establish an institution where, besides preserving the culture, values, traditions, language, and conventions of a religious or linguistic minority community, it also promotes other streams of education without any barriers to children belonging to other religions, it will be highly debatable to discern whether such a university can take refuge under the protective umbrella of Article 30. Having laid down the broad principles to be followed to determine as to whether AMU qualifies as a minority institution within the meaning of Article 30, we leave it for the regular bench to determine such status in light of the parameters laid down in our opinion. We therefore do not deem it appropriate to express any final view as to whether or not AMU is a minority institution within the meaning of Article 30 of the Constitution. Accordingly, we refrain ourselves from determining the factual issue enumerated as issue number 7 in our judgment. So, ultimate conclusions is, thus, drawing upon the comprehensive analysis presented in the preceding sections, we thus hold: 1. There is no conflict between 7 Judge Bench opinion in Kerala Education Bill and the 5 Judge Council Bench in Aziz Basha. The 6 Judge Bench in Siddhas Bhai, laying down that the right under Article 30 is absolute and unconditional, is not the correct principle of law. The judgment is no more binding in nature and stands effectively overruled in TMFI to that extent. Consequently, Aziz Basha does not suffer from any legal infirmity on the premise that we do not cite or follow Siddhas Bhai. Third, there is no substantial difference between doubting or disagreeing with a judgment. That being so, the reference by 2 Judge Bench in Anjuman, doubting the correctness of 5 Judge Bench in Aziz Basha, and referring to a 7 Judge Bench suffers from multiple illegalities, including judicial propriety. In view of the dictum of the Council Bench in Daud Bora, 2 Judge Bench has no authority whatsoever to doubt or disagree with the judgment of the larger bench, and directly refer the matter to a bench having a numerically greater strength than the matter so doubted. The reference by the 2 Judge Bench in Anjuman is nothing but a challenge to the authority of the Chief Justice of India, being the master of the roster, and in derogation of the special powers enjoyed upon under Article 145 of the Constitution, read with the 1966 rules. Consequently, the said reference is not maintainable. However, the subsequent reference dated 12 February 2019, in which the then Honorable Chief Justice of India was the presiding judge, is maintainable. Next, the reference in Anjuman to a 7 Judge Bench for the reconsideration of the 5 Judge Bench in Aziz Basha is bad in law and ought to be set aside. Next, the question bench in Aziz Basha, when it holds that Section 6 of AMU Act 1920 stipulates that degree conferred by AMU would be recognized by the government, it could not have been brought into existence by a private individual or body, is seemingly incorrect. Accordingly, and for this reason, assigning paragraphs 190 B and C, the said decision to that extent is hereby modified and clarified. Further, the minority institutions established in the pre-constitutional era are also entitled to the protection conferred by Article 30. Next, education institutions with reference to Article 30 include universities as well. Next, in order to seek protection under Article 30 of our Constitution, the minority institution must satisfy the conjunctive test, namely that it was established by a minority community and has been and is being administered by such a community. The true import and meaning of the expressions established and administered, which comprise the very core of Article 30, are to be construed and understood strictly in accordance with the indicia in paragraphs 141 and 181. The question pertaining to whether AMU satisfy the above mentioned test of established and administered so as to seek protection of Article 30 of the Constitution, and which will concomitantly entail a mixed question of facts and law, will be determined by regular bench.